In this video, we're going to talk about the use of someone else's trademark as a keyword search term or as a meta tag. In other words, ways that entrepreneurs or startups are seeking to use someone else's trademark in a way so that their website or advertisement can be viewed by a consumer that's looking for someone else's site, and whether this is fair or not fair, or more importantly, legal or not legal. So there have been many cases related to this. Let's first talk about the example of a company purchasing someone else's trademark as a keyword search term or as a sponsored link, so that when someone searches for that company's name, your company's advertisement or sponsored link will be presented on the page of search results. There's been a recent case involving Rosetta Stone where they sued Google because Google had sold the trademark Rosetta Stone as a search term to someone else. And the issue there was whether this caused likelihood of customer confusion and therefore infringed the trademark rights of Rosetta Stone. Now the court in that case, the appellate court, ruled that the mere fact that the use of the term Rosetta Stone was being used in a functional way did not make it okay, did not make it legal. And you had to treat this as any other use of someone else's trademark and figure out whether it was causing a likelihood of customer confusion and go through the multiple likelihood of customer confusion factors we talked about in a prior video. So what was the strength of the mark? Was there actual confusion? What was the sophistication of the people viewing this advertisement on the same page as a link to the trademark owner's website? What are the means by which these companies compete? Do they compete in the same distribution channels? Do they reach their customers in the same way? And what was the intent of the party using the other party's trademark? So these are just some of the factors you'd have to look at. What this means is it probably really matters how you present your advertisement. If you have purchased a trademark owner's trademark as a keyword such that you're seeking to have a consumer view your advertisement or link to your site along with that trademark owner's site, you want to be clear that you're not implying that they sponsor or endorse your site and that you are a competitor if you are. What is the specific relationship between your product and their product, your company and their company? Those are some things to consider. Another way that people will use trademark rights as others is in a meta tag. So in the text that's not viewable by a website user, but is important in search engine optimization. So trying to move your site up the search result listings when someone uses someone else's trademark as a search term. The first thing to know is that the law is unclear, just like for keywords, but it's probably harder to use someone's trademark as a meta tag and have it be deemed a fair use or a non-infringing use of that person's trademark. If you are using it, you probably want to have a legitimate or fair use reason for using that mark. So for example, it needs to be a nominal use. Let's say, again, to take an example we've used before in a prior video, your company sells cases for the Apple iPhone. In that case, there's a legitimate relationship between what you're trying to do and the trademark name Apple iPhone. And therefore, you may be able to use it as a meta tag in order to draw consumers to see your product and describe the nature of your product. A common analogy that's used in this area by courts that find that trademark infringement exists is that if you're driving down the highway, someone else would not be allowed to put up a billboard saying, "Get off at exit 17 because there's a McDonald's at that exit." And let's say you're operating a competing hamburger fast food joint, you could not put up that billboard to confuse consumers to get off at exit 17, and then only your competing restaurant is present at that site. That would be initial confusion of the consumer. You're inducing them to get off the highway, and then you've got them because these people that were looking for McDonald's now are stuck with only your restaurant. That would probably be a situation that's not fair use. You're infringing the trademark McDonald's. But let's take a different example. Let's say McDonald's does have a restaurant at exit 17. They put up the billboard saying, "Get off at exit 17 and enjoy McDonald's." You locate your restaurant on purpose next to McDonald's because you know people getting off at exit 17 are the type of people that are interested in McDonald's, and you think that's the same customer segment you're trying to draw to your restaurant. And so you're just trying to locate your brand in a place that's in the view of the consumers that are looking for fast food hamburgers. That's a situation that may be fair. In fact, in that case, you may not even be using their name as a trademark. So kind of understanding that paradigm may lead you to understand how you would need to structure how you would use someone else's trademark to draw consumers' eyes to your website when you're using that term as a keyword or perhaps even as a meta tag. That's a very general overview of the issues related to intermediate trademark uses, using someone else's trademark on the internet as a way to get your brand in front of a particular customer segment.